guys come quickly. They're not on. All right.
Morning, sir.
You're Jeremy Bender?
Yes, sir.
All right.
First, I want to apologize.
You don't need to say anything. So, all right. Case number, I have two case numbers here. 21 CR 167, which is a new indictment, and 20 CR 81. Both State of Ohio versus Jeremy P. Bender. Mr. Bender's 20 CR 81 was indicted for aggravated possession of methamphetamine and there was a failure to appear, and the court issued a habeas relief, and yeah, habeas was issued on like second. Okay. So Mr. Dennis Kirk, the defense attorney, is present for that, as well as this new case, which is failure to appear, and case number 21 CR 167. Bender, the indictment 21 CR 67, returned on September 14th, alleges that on or about September 1st this year in this county, correctly failed to appear as required in Highland County Common Pleas Court case number 20 CR 81 after having been released pursuant to ORC 137.29. The release was in connection with charge of felony. And that's a 4-3 felony. Was carried upon prison term 26 and 18 months and fine of $5,000. Now, he did that financial disclosure form. Everything on this form is correct. All right. Court appoints Mr. Kirk to represent defendant in this case as well. Mr. Kirk, you were aware of this indictment, I take it?
I am. Would enter a plea of not guilty on his behalf and waive any reading of the indictment.
Okay, thank you. All right. For 21 CR 167, well, actually, we'll go ahead and set these all together. Yeah, the first pretrial, we have our first pretrial in the case item. So we'll set first pretrial in both cases for December the 1st. At 1 p.m. That'll be a Zoom hearing. Final pretrial be December the 15th, also at 1 o'clock by Zoom. And then trial date will be January 11th at 8 a.m. All right, Mr. Kirk, you want to speak to the matter of bond in both of these cases?
I would just ask the court to set a reasonable bond in both cases. Obviously, I'm not going to ask for any type of OR bond as we are dealing with a failure to appear. We would ask for a reasonable bond in both cases.
All right, in 20 CR 81, bond we set at $2,500 plus OR and the $171 service fee prior to release. And then 21 CR 167 bond we set at $5,000 plus overcognizance, which is your promise to appear, Mr. Bender. Fail to appear, as you realize, you'll be indicted, convicted, charged, sentence on that charge regarding back to this case. You'll also be required to pay a service fee in this case, deposit $171 prior to release. In both cases, if you do make bail, you will be under pretrial supervision of the probation department. You report to them immediately upon your release. Once a week for 4 weeks, and after that, as they determine if we're running drug testing in order. Provide current phone numbers for home employer. recommended by the patient to be evaluated for substance abuse and mental health issues may previously indicated to enroll in and follow after commencing this action. You'll also be under house arrest at your residence, meaning you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings, and this or any other case, or appointments with an attorney in this or any other case. You can also attend church services, any kind of educational activities, as well as family holiday events. Again, they can make on. All right. Anything further, counsel?
No, Your Honor.
All right. Thank you.
Mr. Waits.
All right. Case number 18 CR 137, State of Ohio versus Jeffrey Mark Waits. Jeffrey Mark Waits.
Yes, sir.
All right. Like the defendant was convicted back on February 2019 on 2 counts of receiving stolen property, both fifth-degree felonies. There's a notification filed on November the 9th that alleges that you have violated those conditions in Rule 1, that on September 23rd you were convicted out of Brown County Complex Court for 2 counts of theft, and in Rule 2 that you had failed to report to the probation department since March 13th, 2020. And then that, well, actually, November 19th, I see here. Okay. Yeah, November 19th. Now, Mr. Waits, the 2 charges which you were convicted, very possible prison term between 6 to 12 months and fine of $2,500 each count. In the event that you're found to have violated the conditions of community control as alleged in that notification that was filed on November 19th, I can do one of 3 things. I can continue community control over the same conditions previously ordered. I can continue with the additional conditions I think are appropriate. The third and most serious is I can revoke your community control and send you to prison for 24 months and fine you $5,000. Now, you're entitled to have a hearing on these matters. Today's hearing is just simply to notify you what the allegations are. You have a right to have a reasonable period of time to prepare for that hearing. At the hearing, the prosecution would have to show through evidence presented that you have failed to comply with those conditions. You have a right to subpoena witnesses to testify on your behalf in San Diego State. You can testify on your behalf, although you're not required to, can't be required to. It won't be used against you if you don't. And you're entitled to have an attorney to represent you in this matter, to assist you in defending against the charges, cross-examining the witnesses the state present to help bring out evidence to help your side of the case, to advise you on how to approach and defend yourself against these allegations and advocate on your behalf. If you do not have the funds to hire an attorney, the court will appoint one for you if you have no trouble. Now, did you wish to have counsel to represent you in this matter, Mr. Waits?
Yes, sir.
All right, do you understand that if you don't have an attorney, that you'll be representing yourself on these allegations?
Yes, sir.
Do you understand that if you could get found to violate these conditions, or if you admit to the violations, that it could result in you being sentenced to prison for 24 months? You understand that? And what was your sentence out of Brown County?
I received 4 years.
Okay. Prison?
Right. Yes, I'm in prison right now.
All right, well, then just to give you the straight of it is that most likely if you admit or found to have violated these conditions, I'm going to sentence you to prison. It's going to be a consecutive sentence to that 4 years. You understand that?
Yes, sir.
Has anyone promised you anything or threatened you in any way to get you to give up your right to have an attorney?
No, sir.
Okay. All right, officer, do you have a waiver of counsel form there for him to sign?
I can get one real quick.
Would you please?
Yes.
All right, she's going to get a form. I'm going to read this form to you, Mr. Defender. So this is a form we require people to sign in order to document in the file that that person gave up the right to have an attorney. And the form says that I, and then your name will be inserted, defendant herein being now in open court, fully understand under the laws of the state to have a right to legal representation. I do hereby affirmatively waive my right to be represented by counsel. And so she'll put that, your name and case number on that. And then if you want to give up your right to have counsel, then you can sign that. We'll put it in the file. But if you want an attorney to represent you, that's not a problem. Do you have any questions?
No, sir, I don't.
Okay. All right, she'll fill in the blanks there. The case number is 18 CR 137, officer.
Okay, thank you, sir.
Jeffrey M. Waits. Jeffrey M. is in Mary Waits. Actually, it's Jeffrey Mark Waits.
Signature.
Did you hold that up to the camera then? All right, is that your signature there, Mr. Waits? Jeffrey M. Waits? Okay.
Yes, sir.
Thank you. And you understand that that document is confirmation that you are voluntarily giving up your right to have an attorney appointed by the court that you wouldn't have to pay for.
Yes, sir.
Okay. Do you have any questions then about the allegations?
No, sir, I don't.
Do you understand them?
Yes, sir.
Have any questions about the possible consequences if you're found to have violated these conditions?
No, sir.
Right now, the next step in this process would be for you to admit or deny the allegations. A denial is similar to not guilty plea. You're just saying, I'm not admitting to it. I want to have a hearing, which the state will have to present evidence, and you could contest that evidence. And we would set that out about 10 to 14 days from today. Although if you be in prison, maybe a little bit longer because of transportation. The opposite of that is the admission. The admission says you admit that what's alleged there is true, and that you're admitting that you have violated those conditions, Rule 1 and Rule 2, as I read to you earlier. Understand that?
Yes, sir, I do.
All right. Do you have any questions at all?
No, sir.
All right. Do you admit or deny the violations?
I'm guilty, sir.
Okay, so that's an admission?
Yes, sir.
All right. Both counts?
Yes, sir.
All right. Then let me give you that. All right, well, Mr. Waits, is there anything you would like to say as to your disposition in this matter?
No, sir, I just want to say that I'm going to have to take responsibility for violating my probation, and I'm sorry for wasting the probation's time. That's all I have to say. I did pay off all my court costs and everything like that. And like I said, I never tested positive for a dirty urine or anything. I just had a lot going on in my life, and I screwed up and violated my probation.
Well, you did stop recording on March 13th, so probably over a year and a half ago.
Yeah.
What was the date of your offense in Marin County? I know you're convicted on September 23rd. What was the date of that happened?
The date that it happened?
Yeah.
That I was locked up, or
Yeah, the one when the offense was committed, you were arrested.
it was in June of last year.
Okay.
This year.
This year.
Yes, sir.
All right.
I lost three of my family members COVID. My 9-year-old son, my mom, and stuff. Just kind of went out there a little bit, wasn't in the right state of mind, and cast another bad check. That's what I violated on.
Right. Now, you've not been to STAR or anything like that in this case, have you?
No, judge in Brown County told me to write him in a year, and he would probably release me on judicial or whatever it is, and get me into a program.
Okay. All right, well, it's order of the court then that you be sentenced on each of these two counts for a period of 6 months. Those are to run consecutively to each other for a total of 12 months, and that is run consecutive to the sentence from Brown County. I'm having a bail check on any jail time credit. I have a sheet on that. The court finds that protective sentences are necessary given the criminal history of this defendant, that it's necessary to protect the public, and also that he has committed another offense while under community control in this case, and that they were committed as a course of 2 or more courses of conduct, and the harm caused is such that one sentence would not have to reflect the nature of the harm caused, and in fact we had 2 separate victims in this case. And now, upon completion of this sentence, it is possible that the parole authority will put you under post-release control for a period of up to 2 years. They don't have to. It's optional for them to make that decision. If they do, you'll be supervised by a parole officer on the term set by the parole authority, and if during that period of time they determine that you failed to comply, they can return you to prison and make a certain additional period of up to 9 months for any one violation, up to maximum half of the prison term for all violations. But committed a felony, under post-release control, then in addition, whatever sentence the judge in the new case imposed on it, the judge will also sentence you in this case for committing that violation under post-release control in this case to additional period of 1 year, whatever time you would be left on that post-release control, whichever is greater. If that occurred, that would be served consecutively to the sentence in the case. Alright, it says here you have 34 days of jail time credit. Now you're also working at court costs, which has been execution order. If you fail to do that, then the court like that to very clean. Put a ledger on bank accounts, wages, earnings, and other assets that you can have. If that doesn't collect it, then upon completion of the prison term, work on all your interests after you complete your term, the court could order you to do community service and give you credit for each hour you work in an hourly rate set much for each hour you work to produce your judge by that out. Alright, you be remanded back to custody. Thank you.
Thank you.
You gotta read on this.
I can print one out real quick, Judge. I can print one out real quick. I don't think I put it in there.
Alright, yeah, we'll get that. Alright, are you Jeremy C. Purden?
Yes,
Alright. Case number 21-0129, State of Ohio versus Jeremy Charles Purden. Mr. Purden is appearing by Zoom from the jail. The grand jury is counting values you, Mr. Purden, back on August the 3rd of this year for receiving stolen property. It alleges that on or about June 11, 2021, in this county, you did receive, retain, or dispose of property, a motor vehicle belonging to a Joyce Gastiger, and that you do have reasonable cause to believe that it obtained commission of theft offense, violation of 2913.51 of the Ohio Vice Code. Now that offense of receiving stolen property carries a possible prison term if convicted of between 6 and 18 months and a fine of $5,000. Now you are entitled to have an attorney to represent you in this matter, and I see you filled out a financial disclosure form. Is everything on this form complete or correct, Mr. Burton?
Yes, sir.
All right, when was the last time you were employed, Mr. Burton?
Right before I was having some complications here in the jail, and I talked to your court yesterday, explained how I left the jail, and then for that I was working for my dad.
Oh, yeah. Yeah, all right.
Can I add something to it?
Just a minute. All right, this is the first time you've been in court on this case, right?
Yes, sir.
And do you have an attorney in the municipal court case? I don't remember.
No, sir.
All right.
I'm finished in municipal court, sir.
Pardon me?
I'm finished all except for a final.
Oh, okay, that's right, yeah. Been pretty, had a lot of stuff on my plate the last few days, so, I'm happy to keep up on a lot of things. All right, well, I will appoint, Attorney Dennis Kirk to represent you and enter a not guilty plea on your behalf. And I forgot, where are you working, or you say you had a job with your stepdad?
No, my real father, he has a shop in Indiana.
Okay,
He has a shop.
and that 63 Randolph Street, is that where he lives, or is that?
No, sir, that's where my sister lives. That was my old address.
Okay. All right. I'm gonna set your first pretrial for, December 15th at, 1 p.m. Your final pretrial will be set for January the 5th, 1 p.m. Those will be by Zoom. Your trial date will be January the 24th at 8 a.m. Release on your own recognizance, Mr. Burton, which is a real gift. That's your promise to appear if you don't. And you could be prosecuted for an additional felony. And if convicted, sentenced on that, regardless of that in this case. You'll be required to pay a service fee deposit of $171 within 30 days. You'll need to contact the clerk's office to make arrangements to do that. As soon as you release, you report to the probation department on 17 East Main Street, and that's today, immediately after court, as soon as you get released. You don't have anything else holding you in jail, do you?